Hi, everybody, and welcome to our monthly discussion of topics and decisions in the area of patent law, with a particular emphasis on patent prosecution. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I'm Ido Rabinovitch.
We have a great topic today. It's really interesting. We're going to be discussing a few decisions and some USPTO guidance on what's called contingent limitations or conditional limitations in patent claims, which I don't see all that often. Reza, when do we usually see these conditional limitations and things like that?
Yeah, I think you're right. We don't see them that often, but on the other hand, in the methods of treatment claims, in diagnostic claims, and even in computer type claims where there are algorithms involved, one can see these type of limitations. And so it would be interesting to see how the USPTO treats them, and also potentially how one can think about infringement of such claims. So Ido, I think you have prepared some presentation that we can start off with, and certainly we're going to have some discussion about these issues.
Right. Thanks, Reza. So let me just maybe you're all right that this doesn't come up that often. This issue of contingent limitations. It's not a rejection, really. It's a principle of interpretation that is kind of rarely invoked. So we don't see it that much, although I've seen it a number of times during my time as a patent practitioner. Uh, but the kind of genesis of this presentation was because of a case that I was handling where this principle was invoked, and the circumstances were that in the preceding office action, the examiner identified some meaningful allowable subject matter. We had a method, system, and computer product independent claims. And so it seemed like just put everything in condition for allowance, and that would be the end of that. So we did that, but in the next office action, the system and computer product uh, claims were allowed, but the method claim was not allowed because the examiner raised a new art-based rejection on using a first-time cited reference, and it turned out that the reason he did that was because he didn't attach any patentable weight to one of the limitations there, which turns out to be the conditional limitation, whereas he didn't apply the same art or the same reasoning to the system claims and the computer product claim. And so the question is why? That's the starting point for our discussion. So looking at claim one. So the uh, the rationale that the examiner applied and has been applied in some other cases is that the broadest reasonable interpretation for a method or process claim that has a conditional limitation is that only the steps that must be performed during runtime, during the execution of this method, will be considered. If there is a limitation that doesn't necessarily have to be performed during that runtime, then the broadest reasonable interpretation that the patent office takes is that limitation, that step is not part of the method, and so no weight is given to that limitation, which makes it then easier to find art that reads on the surviving limitations. Which is why in the case I mentioned, uh, the system and computer program uh, claims survived, but the method was a new art was applied to the method claim. I will explain shortly why the system claims, device claims, and computer program claims are do not abide by the rule, or the rule is not applied. That interpretation is not applied to them. But for the purposes of the discussion, before we get there, I just wanted to have a simple example of what is the process that the examiner goes through when looking at such method claims. So in my example, there's a method where in the first step we're performing step A, followed by performing step B, and then if a certain condition, which I call condition 1, occurs, then we perform step C. Under the broadest reasonable interpretation, and by the way, the MPEP deals with that principle of interpretation of contingent claims under MPEP 2111.042, Roman numerals 2. Under this principle of interpretation, where the last step is a conditional, the broad reasonable interpretation for that is that it does not occur, and therefore no patentable weight is given to that.
Ido, can I ask you a question?
Sorry,
Sure.
go ahead.
So this opens up the claim for the examiner to apply art, and that's fine. The examiner did in your case. Does it also lead to an indefiniteness type of analysis by the examiner, of rejection under indefiniteness sometimes?
No, it doesn't. Let me, firstly, as I said, in my case, the system and computer program product claims were not affected by that, and they recited the same limitations, just arranged differently in the usual drafting conventions for those type of claims. So there was nothing indefinite in the language itself. It's just that when you interpret it, when you consider what is actually happening during the execution of this method, it's possible that, of course, condition 1 may occur, but it may not. And if it is not, the step C doesn't happen. So as far as the examiner is concerned, step C is really not part of the methodology of the limitation that need to be considered. In the United States, there is no, I mean, there could be a separate indefiniteness issue, but not just because, not by virtue of the limitation happening to have the word if or some other conditional language. So that in itself will not cause a 112 rejection. I'm not an expert on APO practice, but I've seen when similar situations happened, I have seen rejections that do fall under Article 84 of indefiniteness during examination in the APO, where the examiner will say exactly that. It's not clear that this even needs to happen, so it's not clear what the bounds of your invention are. And because they raise this, European examiners raise this indefiniteness, when they get to the art section, it has the same effect as it does here, that because there was indefiniteness, I'm going to treat the claim as if that indefinite limitation wasn't there, which kind of results in the same treatment that is happening in the United States. So this is just a long way of saying in Europe you do get the indefiniteness and the art rejection.
So it seems to me that it makes kind of to some degree some sense that the apparatus, for example, if you have a processor that has been configured to deal with this issue, in order to deal with this sort of contingent limitation, if in the apparatus, there is some structure there, even in terms of configuring a processor, for example, to deal with it. But in the context of the method claim, as you said, there's a possibility that the condition may never occur. So in the context of a pure method claim, that condition may never occur. And so that's, as you said, and therefore the examiner says, well, I'm not going to give it any weight. But to deal with that contingent limitation in the context of an apparatus or a processor, you still need to program the processor to deal with that contingency. So that structure is present in the context of the apparatus. So they need to give it weight, but not necessarily here.
That's my next slide. Dealing with, in my next slide, I talk about the fact that system claims, whether they're apparatus, device, or product, those claims, when they recite contingent language, there is no, and that's by the MPEP itself in 211104 that makes that statement. And it's exactly for that reason. Whether or not, the question in system claims is not whether something will be performed during runtime. Infringement of a system claim occurs as soon as the system or device comes to existence. And so it doesn't need to actually perform anything. It just needs to have the structure that would allow it to do something if you're once you do use it. And for exactly the reason you mentioned, Reza, the system claims, the way we draft them is to say, when we use functional language, which is often with a lot of processor-based devices and inventions that they do that are based on some processing, the claims basically define what the black box is configured to do. And so it has been programmed to deal with the various contingencies. It's all there. As soon as it comes to existence, everything in that black box that it's capable of doing is part of the product as defined by the claim. And so there, and that's also explicit in the MPEP. For those type of claims, the system claims, the computer program product claims, that interpretation does not apply, which is exactly what happened in my case, where the system claims, reciting the same limitations as the method claims, were allowed, whereas the method claims was rejected by adding one kind of simple-minded reference to reject it on 103 basis. And as now that we're on this claim, I wanted to mention that the contingent claim rule is not invoked simply if we use the word if. It technically can be invoked for any language that is deemed to be conditional. And I often write claims that implicitly have some conditions in it. And when we draft applications, I mean, very often we have flowcharts that to correspond to the method claims that are just blocks of things that happen in sequence. But occasionally we also have conditional junctions, diamond-shaped decision nodes that branch into two separate areas. And that in itself implies that whatever method you have has some condition in it. And the examiner could, in principle, apply that rule because language like in response to, when, whether could also be considered to be a contingent language. Any of those could potentially fall into the trap. I haven't seen, I can't say that I've seen any office action where use of that language was captured under the rule. I think the examiners appear to have more tolerance for language. My favorite go-to conditional languages in response to, or I also use upon determination of something, but we can discuss that as we wrap up, as we get to some solutions to how to overcome, how to deal with contingent limitation interpretation. And using those constructions doesn't seem to trigger the examiner into raising those interpretation principles. The only other thing I wanted to mention on this slide is that the rule of interpretation is dealt with at 2111. That's when they talk about the broadest reasonable interpretation. There's also mention of it in the obviousness section of the MPEP in 214303. That refers to the all limitation rule that when you examine an application, when you examine a claim, you can't just ignore, you have to take into account all the limitations there, whether there were any problems with indefiniteness or whatnot. It's just to make it the prosecution more compact. But this section of the MPEP, 2143.03, explicitly says that when you have contingent language, you can ignore that limitation. So that's an exception in the MPEP for the old claims, for the old limitations rule.
Ido, do you so thinking about this, I sometimes use these. I'll use a where and when clause in a method of diagnosis or method of treatment. Because you'll say, measuring a certain plasma level of an analyte, where and when it's above a certain value, you'll do some kind of treatment or something like that. But I've never seen an examiner cite this part of the MPEP, but they may say it doesn't have patentable weight. So is that another way that they may approach this?
Maybe. I mean, they need to explain why they're not giving it patentable weight. The other classical situation where an examiner will not give patentable weight is when you have a list of options wherein element A can include one of A prime, a double prime, a triple prime, and so on. And all they have to do is just find reference that has one of those sub-elements, A prime, and that's it. So it's almost it's understood without the examiners usually adding any additional explanation that they didn't look at those other two sublimitations, those other two optional elements in that list, Marcouche list, or any type of list of alternatives. It's understood that no patentable weight was given to anything but what they're citing in the office action. When you're invoking that rule, I think the examiner, I certainly in the office action that I saw where this issue came up, they did specifically refer to 211104. So it doesn't mean, of course, that other examiners will do that. They may just decide to leave it to us as to guess why exactly something was not considered. But I think when you invoke something that is fairly rare, they would go through the exercise of saying, this is why we didn't consider it.
Another thing that comes to my mind is that, I mean, you're right that writing in response to or using when may be an option. The question, I guess, that one may think about is that, let's say it gets allowed, but then it gets challenged either in litigation or IPR. But I guess the rule of construction in those situations are different. It's sort of ordinary meaning rather than broadest reasonable interpretation. So in those contexts, then that element of the claim, the conditional element, should be considered for validity, I suppose. So the question is, if it goes through but then gets challenged, what happens then? But it seems to me that there's a different standard for claim interpretation. It's not broadest reasonable interpretation in those stages. So maybe it's okay.
That's a good point. I have a case. I'm going to talk shortly about a case where that issue came up. The standard of interpretation that was used in that case was not specified. It almost seemed that they entertained the appellant, the defendant. It was an invalidity action, so the party trying to invalidate did not specifically acknowledge, and there was no acknowledgement by the court that there's a different standard of interpretation. They did go through the exercise of considering the way that the USPTO, with under its broadest reasonable interpretation mandates, handle the case, and whether it's wrong or if there's any exception. But I'll get to that in a second. I'll now move to the important case that is the basis of this rule of interpretation, which is Schulhauser, which is a 2016 case, a presidential case that went to the Board of Appeals in a regular examination, or a regular ex parte examination of an application. So here it was the standard of interpretation, of course, is still the broadest reasonable interpretation. And even though it was a PTAB decision of the Board of Appeal, it was considered to be important enough that it became the precedential authority for this rule. And in Schulhauser, you had it was a fairly simple claim. Basically, you had an electrocardiographic signal, and you compared it to some threshold criteria, electrocardiographic criteria, and it would trigger an alarm if the claim language specifically used the wording if the electrocardiographic signal was not within the threshold, and it's in the event that the electrocardiographic signal was within the threshold, it did another function, which is determining the current activity level of the subject. And the Board of Appeals said that the two limitations that had the if statement in them were mutually exclusive, and that only in evaluating in considering the patentability of the claim, only one of those limitations had to be considered, and presumably the one that where it was easier to find art, the thread on it. So really the full scope of the operation of this rule is that It's not that you disregard all limitations that have a contingent language in them. You disregard if you have more than one conditional statement and they're mutually exclusive, that one can happen, but the other necessarily would not happen. Only one of those conditions would need to be considered. And so with this rule, I want to go back to the example I gave at the beginning. And the first slide where we had performing step A, performing step B, and the if condition one occurs, performing step C. The correct way to look at it in view of Schulhauser is that you had only one condition, and the mutually exclusive part of it is that if that condition didn't happen, nothing happened. So that was your fallback. Either a condition happened and you performed step C, or nothing happened. And in that case, you do consider the nothing happened scenario, because that's what happens if the condition didn't occur. So in fact, you did have two situations, two scenarios, and the examiner just picked the easier scenario to handle, which is nothing happens. So that is the more correct way of looking at those conditional statements. Does that make sense?
So, if you want to sort of then potentially you can split a claim in two claims, or maybe one independent claim, one dependent claim, where the dependent claim just recites one condition, and then the independent claim recites the other condition. How would that work? Would that help in that situation?
I think that will take you to this simple example. If you only have one condition and you don't say what would happen in the event of another condition, of the condition not happening, then the interpretation of the claim is that you have step A, step B, then you have a condition, nothing that specifies in that claim, nothing that tells you what happens if the condition does not occur. And therefore, the full method is step A occurs, step B occurs, then nothing occurs. So if you just added a single conditional statement, that gets you exactly to this problematic scenario where you don't get any weight. If you specify both conditions, if you specify two conditions, and only one of which can occur, at least you'll get that one of those conditions considered, but more likely than not, it'll be the condition that is easier for the examiner to map to some prior art reference.
But what happens if the totality of things that can happen is either A or B? One of them would inevitably happen, meaning that, we talked earlier that a condition may not happen at all, but if you have a situation that you have A or B, but one of them will definitely happen, how does that play into this?
Well, that's exactly what Schulhauser says. If you have two mutually exclusive conditions, and one of them has to occur,
Right.
then only one of them will be given patentable weight. And it will be at the convenience and the discretion of the examiner which of those two conditions to treat for examination.
I see.
And if we have more conditions, I think it'll be from a logical point of view. If a certain outcome, if a certain decision or condition can have three separate outcomes that are all mutually exclusive, it's either a value is either between 1 and 33 or between 34 and 66, or between 67 and 100, you and different actions take for those different ranges, the examiner will only have to deal with one of those, the action happening in only one of those ranges, because they're all mutually exclusive. They cannot all happen at the same time. One of them will happen, two will not.
Is it possible? I'm just thinking of a situation where you've got possibly a method of treatment claim, and you have two if-then statements or where and when clauses or whatever. And one outcome is surgery and one outcome is administration of a drug compound. Can examiners do an election of species on that, or just call it two separate groups? You know what I mean? Like, could they split these up and say, well, this is two separate inventions?
They wouldn't. I don't think it would be a restriction required. It would just be a principle of interpretation that they apply, where if there are mutually exclusive conditions, they could just decide to disregard one
Oh, just ignore the other
limitation.
one.
They wouldn't split it.
Mm-hmm. Okay.
And which one they decide to examine, I guess, it depends on how easy it is to find art for whichever action is. That would be their discretion.
Mm-hmm.
Um, as I said, I mean, we all as practitioners sometimes not really realizing it, but we draft conditional statements into claims. And I've done it plenty of times with using language in response to, or as I said before, upon determination of something. I mean, that's conditional, but I haven't gotten any pushback for that. It seems like the trigger is the if statement, the actual wording if. If when an examiner sees if in the claim, it raises a flag, I guess. Maybe they are trained in that. It's a 2016 decision, Schulhauser. So that section of the MPP was presumably added 2016. So it's not clear that all examiners are even aware of that, or that they go over that principle during their training, which is why we're not, it's possible that's the reason we're not seeing a lot of those rejections. But I think just generally, it's more of an aesthetics, it's an aesthetics issue, that if you have an if, firstly, it's not a great way to write a claim. You shouldn't be using that. It's a little clunky. But it's the exact trigger word that might send the examiner to look again at this section of the MPP. So let me go over an exception to Schulhauser, and that was the Hytera case, and that was from the Federal Circuit, a 2021 decision. And surprisingly, that's non-precedential. It's a little surprising, given that it's high authority, but as far as the as far as the USPTO is concerned, that's not. It doesn't have any precedential value. Although I think if similar situations arose, then I think some weight would be given to that. It is, I think, a more credible authority than PTAB. It's certainly higher there in the hierarchy. This specific case did come from litigation. It was an appeal from an IPR where the petitioner, the requester of the IPR, was looking to invalidate a claim by Motorola, the 8279991 patent. And on my slide, I reproduced the important part of the claim that was at issue. And it included a first limitation that turned out to be the key to the case of knowing the first set of synchronization patterns and a second set of synchronization patterns, then determining what time slot you're in, and then you had two conditional statements. If a time slot was the current time slot, then you select the synchronization pattern from the first set. But otherwise, if it's not the current time slot, then you select the second set of synchronization pattern. And the requester said, well, this is classical Schulhauser. You have two conditions there that are mutually exclusive. Then, in which case, you only need to find R to invalidate one of those conditions, that reason one of those conditions, but you can disregard the other. And what the court said was that this is different from the Schulhauser, because here we have the specific limitation that we determined ahead of time, ahead of reaching these conditional limitations. The first set of synchronization patterns and the second set of synchronization patterns. That is part of the claim the claim limitations, regardless of what decision is made on the contingent limitations. And because you went through the trouble of finding those, knowing, which I think the old man was determining, because you actually found the first set of synchronization patterns, it's essential that some use would be made with both synchronization patterns. Why would you find two of them and then not use one of them? And I think a better way to look at it, I think it's just kind of maybe the rationales. I think the way to think about it, what they were trying to say is that if the examiner already went through the trouble of finding art that had those two separate, different synchronization patterns, why wouldn't you then go on and consider both if limitations? You did find, I mean, presumably you had to have found a first synchronization set and a second synchronization set. So, according to Hytera, as long as if you have certain actions that happen in two separate limitations, contingent limitations, as long as you made an effort to do something, to find, determine, or some other preceding action with those two conditional actions, that would overcome the issue that was determined in Schulhauser.
But
when we draft these claims, we want to think about, if we want to make sure all our conditional limitations are considered, you need to have steps that produce or provide all the possible outcomes. So provide drug compound A, drug compound B, drug compound C, and then we have if the patient's plasma levels are within a certain range, provide A. If within this range, provide B. If within this range provides drug C. So theoretically, according to this, all three of those would have to be looked at by the examiner. None of them could be considered, not having patentable weight or anything like that. Is that kind of the concept?
If drug A, I mean, if drug A, B, and C were given no matter what, under any circumstance in which this method of treatment was performed, then they wouldn't fall into this rule. It's only if you kind of say drug A is administered if under these circumstances, drug B will be administered under circumstances two, and drug C will be administered if the third set of circumstances happens. Those could potentially fall under the Schulhauser, the Schulhauser rule, the Schulhauser doctrine.
Mm-hmm.
In this case, it looks to me that the limitations were things that had been determined in advance, right? As you were saying and Joe were saying. So a lot of times that's not the case, right? I mean, if I, for example, if I find this type of bacteria, I do A, but if I find a different type of bacteria, I do B, those are not limitations that I have. They're not part of the claim, sort of constructing those limitations. So in a way, we still back to some degree to Schulhauser, and the limitations that the Schulhauser provides in that regard.
I think, I mean, if this went to litigation, if this was considered by the Federal Circuit, and Schulhauser was not considered by the Federal Circuit,
right,
as far as the Board of Appeal and PTAB. To go back to Joe's example, if we specifically recited a limitation of providing drug A, drug B, and drug C, and then determining level of determining identity of bacteria or level of bacteria, there's a chance that this could be interpreted under the Hytera, the formulation of Hytera, where the fact that you provided A, B, and C means that you considered all of them to be an essential part of the limitation. You wouldn't gratuitously just decide to throw in A, B, and C. You're going to do something with them. Otherwise, it's kind of a nonsensical limitation. Provide A, B, and C, but then only A has any follow-up within the claim. So under the Hytera ruling, that could be a one way of trying to overcome any such problem in terms of the examiner's treatment of the claim. In terms of, now we're in the section of how to deal with that, and I guess the first thing we should all avoid is using the express recitation if. We shouldn't, and I don't think I've ever used if. I've seen if being used, but I just find it a little too algorithmic. I'm always afraid that it would raise a one-on-one rejection, that it's nothing more than an algorithm that is in the capability of the average person, skill in the art. So I avoid it partly because of that, partly because I just don't like it. But I think it's also given the consequences with contingent language, and that if seems to be the main trigger word, it's a good idea to avoid it for that reason too. As I said, and then as we were discussing Joe's example, you could, if it does come to an issue where the examiner is imposing that Schulhauser interpretation, then you could do what we just mentioned, positively recite an action of determining or providing some of the actions that are then used in the conditional limitations, and that might overcome the problem. Although the examiner is really stubborn, you could say, no, Hytera is non-precedential, so I'm sticking to my guns, pick it up with the appeal board if you want.
You know, there's another set of claims that comes to mind in the diagnostic context, even in terms of apparatus, you know, sort of detecting bacteria, if any, in the sample, let's say. That sort of, I've seen if statements in that context. And I guess, you know, one school of thought is that you don't even need it, just say detecting bacteria in the sample, because after all, if it is there is where you want to detect it. If it isn't there, then it's not detected. The other side of that discussion is, can somebody make an argument that a lot of times in my device, the bacteria is not being detected, so because it's not there, it's not there, therefore I'm not infringing, which I don't think probably wouldn't fly necessarily, but that's another place that I have seen if statements in the sense of detecting whether something is present, let's say, in the context of diagnostic methods.
Yeah, I mean, I think those, I've drafted claims of that nature where it's not certain, it depends on some measurement or diagnostic being performed before any other action is taken. And it's true, sometimes something will happen, and sometimes the diagnostic will be positive, and very often will be negative. As long as you can prove, and I don't think there's any problem then with the claim itself, because as long as you can prove that it occurred one time, and proving method claims is difficult because it needs to occur at actual use time. Um, but as long as you have that proof, I don't see any problem with having a claim of that nature. Again, it would be better to um, avoid any if statements. It can be assumed that if you want to incorporate both the performance of the diagnostic and the therapy that follows it, then I think language such as performing diagnostic tests to determine number of pathogens, number and identity of pathogens in a blood sample, and administering or in response to detection of the pathogen or specific pathogens, do take whatever therapy. I mean, that
In those
kind of gets
cases,
to,
sorry to interrupt you. In those cases, typically there are also device claims which wouldn't suffer from this issue.
that's exactly. So yeah, I mean, the bottom line for me is that this only affects method claims. And I don't know that I really deviate from my usual drafting strategies just because of a method claim. If the claim language is good and it captures the invention for a system claim or for a product claim, then use it there. Those are not going to be affected.
Right.
And for the method claim, you can take corrective actions if and when this issue comes up during examination. The examiner does decide that for the method claim, he doesn't like all those conditions. But another approach, another strategy that is really just a drafting exercise is to try and express those limitations, those contingent limitations, without invoking any contingencies. So let's take the Hytera example. So in the Hytera, we we had to find the first set of synchronization patterns, and we had to determine the second set of synchronization patterns, and then we picked one of them. Why not say, instead of the if and otherwise statements, something to the effect in my last slide of selecting a synchronization pattern from one of the first set of synchronization patterns or the second set of synchronization patterns based on the identity of the time slot. And that's all. That's not really a contingent limitation. It's not a conditional limitation. We're taking an actual specific action of selecting, and we're selecting from one of the two available synchronization patterns.
Yeah, that makes sense.
Yeah, I think you know, I think this is a good strategy. The other one I like, Rez, is the one you had mentioned. You know, drop these options down into two separate dependent claims. You know, have your main method claim sort of end with the determining step, and then your options of whatever you're going to do next are going to be claims 2 and 3.
Right.
I think that kind of then the examiner's got to examine it, and it doesn't run afoul of Schulhauser or any of this stuff. And you know, it just to me, it's cleaner. I don't really like these, you know, these conditional limitations so much.
I think
that's a perfectly good way of going about it. I mean, you'll know once we have now this awareness, and I think whenever I wrote in response to, or when I use those other magical words that are really conditional, I am aware there's a condition, and I wasn't maybe fully aware of the consequences that this something like Schulhauser might be invoked, but I was aware that it's conditional, and now that we are aware that certain limitations might be construed as being conditional, do exactly that. Just don't recite conditions within the independent claim. Go up to the determining and try to maybe make the conditions into something more generic that perform some generic version of step A or step B, which appear in the conditional limitations, form it in the independent claim, and then in claim 2, wherein performing this generic action advises performing the action 1 upon determination or when this condition happens, and then go to condition 2 and to claim 3 and say and recite the other condition and the action. And that should do it.
Yeah, this was a good discussion. I think this is great. Thank you so much, Ido.
Yeah, thank you. This is really interesting. I think it's a good topic. It's really, really excellent. Thanks.
Thank you.